says to not use during parenting time, and I do not do that.
All right, we're on the record in the matter of Moore versus Moore. Currently, I appeal. It's my understanding, Ms. Day, I did ask you prior to the beginning of the calling of the case whether Mr. Krupp was still on the matter, but you say that you have information that he is withdrawn from the case, correct?
That is correct. I have in front of me on my computer, and I can forward this to the court as well. There was a stipulation in order to withdraw as plaintiff's attorney that was entered by the court on February 7th of 2024 and appears, it's got Judge Bryant's stamp on it. But it looks like it was signed by both Mr. Krupp and Mr. Moore.
So Mr. Moore, Mr. Krupp is no longer representing you.
Correct.
Okay. Now that we have that settled, Ms. Stay, this is your motion. Anything you'd like to add to it?
No, Your Honor. I know that you've obviously had a chance to review the motion. The only other thing that I would point out is when we were back in court and we were in front of referee Peter Coulis Dominguez, this was back in March of 2023. The order was entered on March 28th of 2023. That's when there was a modification to the judgment, which stated that the plaintiff was prohibited from utilizing marijuana at any time. Went on to require him to do a couple different hair follicle tests to make sure that he was no longer using marijuana. And one of the provisions within that order stated that if plaintiff fails or refuses to submit to either hair follicle test, or if the second hair follicle test shows marijuana in the plaintiff's system in any amount, his parenting time shall be immediately suspended until further order of the court. That wasn't in the last order. That was when we were in front of Judge Bryant, but she did order that he do another hair follicle test because he hadn't done one in August, which was required under the original judgment. But she made it very clear on the record that if he did test positive for marijuana, that she wanted this brought back to court to address that. And I guess from our position, it seems that it would be appropriate to follow the direction from the prior referee that had handled this, indicating
at this point it's a prior court order, and once it's been processed, it's a recommendation by the referee that is now signed by the judge and entered as an order of the court. So it's not necessarily who did it; it's done.
Yeah.
But,
so from our
you're
position,
basically this is more of a motion to enforce previous orders.
Correct.
All right, and that's the only question I had of you was because subsection B of your prayer for relief was rather vague as to what you were requesting for parenting time. So that's what I was going to have you clarify. You've just clarified it by the former order of the court. Mr. Moore, what is your response to all this?
We just met with Shantina on Wednesday about the mediation for a recommendation or what they would suggest for our parenting time schedule. That was just sent. That was just done Wednesday, so I didn't know what was going to happen today. I just found out Wednesday that she wants to what she wanted as far as to take away my Wednesdays and my overnights. But I talked with Shantina, and she asked me if I have ever thought about going and getting a med card. And I wanted to originally do that back in the original order, but this Chris Krupp, he suggested that we just continue to do what we're doing, so I don't look like I'm trying to avoid any responsibilities as far as a hair follicle test, because she was accusing me of hard drugs, and that was proven to not. And I use marijuana a couple times a week for my back pain because of my major accident that I was in back in 2011.
All right.
And that's it.
Yeah, no problem. Well, one of my first questions was going to be answered by your presence, which is, how long is your hair?
Oh,
I can see it. No, I mean,
because
I've had people that had hair down to their shoulders, and depends upon how long your hair grows. If they take the very end of it, that positive test could be a year old. But in your case, that's not the case. So I unfortunately have to enforce the previous court order. And here's what I would ask that happens. The parenting time is suspended. Once you get two positive, at this point, you're going to have to show two negative tests. Okay. So find something else for the pain for now. see a doctor, and then if you wish to continue to use marijuana as a pain relief, then file a motion with that doctor's note and the 2 negative tests saying that you would like to proceed with using it and utilizing it for medical purposes. And that way somebody can maybe give you an estimate as to how much would legitimately be in your system for medical. I don't think they've actually tested that, but maybe something's happened in the past 3 years I don't know about. And then you can argue with the court whether you should be allowed to use medical or marijuana for medical purposes. But that's going to have to be a decision made by the court, because the court's current order is you're not allowed to use. So I have to go with what the judges have said, what the judges ordered.
And it says to not use during parenting time, and I do not do that.
I understand, but it also says that if you test positive, and this is the consequence of the positive test. I'm kind of stuck with that at this point. What I've just notified you of is a method to get out of it, but that's going to take time.
So I have to possibly go 60 days without seeing my daughter.
Potentially, yes. Unless there's other agreements. All right.
Is this okay? Is this final? Is this what you want? Sarah,
this is a recommendation by me that has a 21-day objection period to it, but it would be the judge that would be seeing it, and that's the judge that ordered this. So that is up to you. All right. Good luck, everybody, but that will be my order. I'm granting the order. I believe that order also ordered automatic attorney fees as well, correct?
It wasn't automatic attorney fees, but
Okay.
Attorney fees have been reserved twice now for enforcement issues. And so the last order of the court was that, again, that attorney fees would be reviewed. My recollection from what the judge said is if we were back here again for a violation, then she was going to order attorney fees.
Right. Inherent in this is a punishment that's awful, which is the not seeing of his child. But I am going to grant $500 in attorney fees at this point because of the continuing issues with this. And yeah, you're going to have to get permission from the court then to use the marijuana for medical purposes, Mr. Moore. All right. Good luck to you. And I can't guarantee whether the court is going to grant that or not, because the doctor may issue you something else.
I understand, sir.
Yeah, that might be the better place. Okay.
What do you think your child support amount should be?
I think $750 is more than enough to take care of one child that's 6 years old and in school. I work more than 6 months out of the year away from my family to get to where I'm at, to provide for my family here at my house. And I don't see how it's fair that I work hard to better myself to have it taken away from me and my family here at my house when I have to drive 9 hours away from my house. I ain't had Christmas home in 4 years. I miss out on a lot to get to where I'm at. I don't see how it's fair just to have it taken away from me.